Now, what I want to do is to say some things first on the nature of the Sharia as such, then something about how laws of apostasy and of blasphemy have developed, and what is being done about them, if anything, and then perhaps to close with some general comments on how the legal tradition actually affects people's attitudes. So even where it is not possible to have technically laws of apostasy or blasphemy in force, that it still affects how people think, their mindset. Now, as you will know, that the word Sharia comes from a term that means a way, and clearly it is for Muslims a way in which they follow the what they believe to be the eternal teachings of the Quran and of the Prophet of Islam, Muhammad. But Sharia itself is a spiritual term, therefore, in that sense. It has to do with what people regard as the way to follow for them in terms of their religious commitment, if you like. But the teachings of the Sharia are given legal effect, if you like, as well as social and political, by a process of codification from the very earliest period, and the first codification was actually a Shia codification, a Zaydi codification. But in the first 200 years of the history of Islam, the Sharia was codified into what is known as fiqh, that is to say, a specific legal provision. And when people refer to Sharia law, it is very often they are referring to specific aspects of fiqh. Now, as I say, the first codification was Shia. It was a Zaydi codification. But since after that, over the next 200 years, Sunni fiqh was also codified, and there are four main schools that survived, although there were many more in the beginning. The four main schools, or the madahib as they are called, of law among the Sunni. There remain also, of course, schools of law among the Shia. Now, these schools of law are based on what are sometimes known as the usul al-fiqh, the principles for lawmaking. And the usul al-fiqh have to do with the roots, the sources of Islamic law. For example, they have to do with the authority of the Quran itself, of the Sunnah, or the practice of the Prophet, which of course includes also what he said, the ahadith, and then they have to do with what is known as qiyas, which is analogical reasoning, so that what was prescribed in certain circumstances can also be applied in other different circumstances. To give you an example, the Quran and the Sharia, and indeed the various schools of fiqh prohibit the drinking of khamr, which is grape wine. But by qiyas, by a process of qiyas, through analogical reasoning, that is also held to mean, in most schools of law, that whiskey is also prohibited, because whiskey or spirits generally have the same intoxicating effect as does khamr. So qiyas is another principal way of developing fiqh. Then there is the agreement of what at first was the companions of the Prophet of Islam, Muhammad, known as ijma, which later came also to be understood as the agreement of the scholars about important matters. So those are the principles or the roots, the sources of Islamic law of various schools of fiqh. And then they result in what are known as the furu' al-fiqh, the various branches of law. And these became comprehensive, all-encompassing of the lives of people. They were divided into the ibadat, that is to say, those that had to do with the cult, with the ritual of the faith, and the muamalat, which have to do with the affairs in the world, in the family, politically, in the state, economically, and so forth. Now, as I say, there are many, many different aspects to fiqh, to Sharia expressed as fiqh. Before I come to apostasy and blasphemy in particular, I would just like to mention two, because I think they are of some relevance to what I'm going to say. The first is the development of the dhimma. Now, this has its roots already in the practice of the Prophet and indeed in the teaching of the Quran about how non-Muslims are to be treated in a Muslim polity. And as you know, at the very beginning of his time in Medina, the Prophet of Islam instituted a constitution known as the Sahifat al-Madina, the Constitution of Medina, which recognized not only Muslims, not only the Muhajirin, the refugee Muslims from Mecca, and not only the Ansar, the helpers from Medina, but also the Jews and other communities as equal citizens in the new Islamic state. I think this is quite important to note, because when people say we want to have an Islamic state here or there, the question is, will it be like the first Islamic state? And if not, why not? However, the Sahifat al-Madina, the Constitution of Medina, only lasted, unfortunately, a very short time. And in fact, the origins of the dhimma lie in something else. They lie in what happened to the Jews of the Khaybar, whose fortifications were reduced by the Muslim forces, and who were allowed to continue with their work, which was mainly agriculture, on condition that they paid half of the produce to Muslims. Similarly, the Christians of Najran were able to conclude a treaty with the Prophet of Islam. It's a very interesting story in itself. They were invited to Medina, they were lodged in the Prophet's mosque, they were even allowed to perform the divine liturgy in the Prophet's mosque. And if you know what happens to non-Muslims if they try to go to Medina and Mecca today, then it is quite interesting that the Prophet himself did not in any way act like that. However, again, with the Christians of Najran, a treaty was made on the basis of tribute being paid to the Muslim community. Now, when Islam expanded into what was then almost wholly the Christian Middle East, the great Christian cities of the ancient world were not in Europe, they were in the Middle East. They were Alexandria, Damascus, Jerusalem, Constantinople, and so on. The dhimma became a very important way of organizing the relationship of the Muslim conquerors with the conquered populations. Certainly this business about paying a special tax remained characteristic of the dhimma. The people of the book at first, the Jews and the Christians, were allowed to continue to practice their faith. Later on, this was extended to the Zoroastrians when the Muslim armies conquered Persia. And later on, when they arrived in the Sindh, in what is now Pakistan, and therefore in the South Asian subcontinent, it was also extended to Buddhists and to Hindus. In the provisions for the Dhimma as they were elaborated in fiqh, the non-Muslims were allowed to continue to practice their faith on condition that they paid certain taxes. They were, of course, not allowed to serve in the armed forces or in the higher echelons of the civil service. They could maintain their churches but not build new ones, and synagogues as well. I was talking to an official in a Muslim country who was telling me about how Christian churches are being maintained, and I said, well, are new ones being built? And he said, no, that's not allowed, because the Christians don't need new church buildings. And I said, well, how do you know? I mean, I think that should be for Christians to decide, surely. They could be repaired, but with the permission of the Caliph. They could not show any external signs of their religion. Nor could they, of course, ring things like bells to show that they were there. The houses of the dhimmis had to be more modest than those of the Muslims. The dhimmis in general were not allowed to ride horses. It's a martial animal, but only mules and donkeys. They had to give way to Muslims in the street. And when they came to pay the jizya, the particular tax which was levied on them, then that had to be paid to show that they had been humbled. That was sometimes done with a ritual blow on their neck or in some other way. They had, in some cases, had to wear special dress that identified them as dhimmis. Now, the dhimma is assessed in a number of different ways. Some people, like Montgomery Watt, think that the dhimma was an advance in those days in at least allowing people of another faith to live within Muslim polity. And certainly in the development of fiqh generally, many of the Muslim lawyers used the previously existing codes of Christianized Roman law, the codes of respectively Theodosius and Justinian. And many of the provisions of the dhimma were actually taken from how non-Christians and heretics were treated in the Eastern Roman Empire. However, there were some features like the humiliation at the paying of the tax, the special dress, those sorts of things that were new in the provision of the dhimma. So was it an advance? Well, perhaps in those days, in those terms, it was, though the dhimma, as has been noted, resulted in a particular depressed mentality among the non-Muslim communities of the Islamic world. What has been called dhimmitude, a particular way of thinking about their life and their prospects and their relationship to Muslims. The other problem is that even if it was a way of relating at that time, since the 1950s, since Maulana Abul Ala Maududi wrote his Rights of Non-Muslims in an Islamic State, there have been attempts to reintroduce the dhimma into Muslim societies. So non-Muslim citizens who were equal with their Muslim fellow citizens found themselves suddenly being regarded as dhimmis. So that, however you assess the dhimma, that remains a problem.